Here's the phone call to the courthouse.
Valley Municipal Division. Our office hours are 8:30 to 4:30 Monday through Friday. For additional information, you can locate it on our website at o'fallon.mo.us. There's no continuances granted outside of the courtroom. Please listen to all the prompts before selecting. For court date information, press 1. For attorneys entering on a case, press 2. To check on an inmate status, press 3. For payment options, press 4. To speak to the police department, press 6. To be transferred to City Hall, press 7. To speak to the prosecutor's clerk, press 8. And to speak to a court clerk, press 0. O'Fallon Municipal Court.
Hello, my name is Joe Pierce. I have a hearing scheduled there today at 5 p.m. and I'm just calling because I had a few questions about what to expect so I can prepare. I have a case number here if that helps you.
Okay, hold on 1 second.
Okay.
Alright, what's that number?
Well, there are two numbers. It's all for the same case, but it's 230-378-706, and the second one simply ends in 707.
Okay, what is your question?
Well, it was always originally scheduled for Wednesdays. This was originally filed on July 22nd of last year, and now it's scheduled for Monday, and the event is just listed as a hearing. And so I'm wondering what to expect. Why is it Monday at 5 p.m.? And what is the nature of this hearing? Is it a pretrial conference? Is it a motions hearing? Is it an arraignment? Is it a trial? What is?
No, it's just a hearing. You just need to come in and enter a plea.
Okay. So that would be what they would call an arraignment. But okay, so why is it Monday? Is it still going to be Judge Engelmeyer?
Yes.
And it's Monday and not Wednesdays because why?
That's just the next court date that they set it for. It looks like this case is pretty old, so that's probably why they just gave you the next date.
Okay. So I've had motions filed there. It's in my case file. They're months old, attempting to use the Missouri law that's posted on the wall right behind the prosecutor's office there in the building to get this judge recused, and it says I can for any reason. I've actually already used it in another case against the judge, and he complied immediately, didn't have a problem with it. I've been trying to do that with this judge, and he will not let me speak. He won't let me introduce it. I let the office know, please communicate it, and it's being dodged, so I'm just letting you know that's all I'm trying to accomplish. That's all I've been trying to accomplish, is to get a different judge in accordance with the law posted in your building. Is there any reason you can think of why I can't expect to come in and have that law enforced?
I'm not sure. I mean, I can see all your motions in here that you've asked for the judge to recuse himself, but let me put you on hold for 1 second.
Yeah, please communicate this. I appreciate it. Well, they don't care to hear your response. This is not customer service. So, obviously I'm on hold. Just kind of thinking in the meantime. You know, you just go through the variety of answers they could come back with, because they're communicating to the powers that be, right? That shouldn't be. Hey, this guy's calling for this reason. What do you want me to tell him? And this is just my very first question, right? I have 5 points to go over. She said, what's your question? So I started with the top one. What is this going to be? What can I expect? Of course, she's not a judge. She has no power, and if I reference that this is what she said, it won't have any weight in the courtroom. They'll just do whatever they want, even if it's the opposite anyway. So I kind of hope they extend wait times unnecessarily to see if the person will be talking on the phone in the meantime, so they can record them when they think they're not being recorded or anyone's listening. I don't know. I don't really think that's going on, but if it was, it'd be funny, because what they don't get is that. No, it's fine.
I'm not sure why has not, but that would be a question that you would need to ask him. Unfortunately, I can't speak for the judge.
Sure.
But you will. You do have a hearing tonight at 5. That you'll have your opportunity there to ask those questions to him, and it would be up to him if he, I guess, wants to or not.
Well, the law says it's not up to him. It specifically says that even if the judge doesn't think that the reason is valid, that the judge gets to be changed anyway. It specifically states that, and it's posted on the wall, and I've pointed at it with my finger and communicated this previously. The previous hearing was on July 16th, and any attempt by me to bring up that law, or the fact that I filed a motion referencing it and just wanting to use their own rule, was silenced and met with a threat of contempt of court while they continued with a bench trial, not allowing me a jury, and put the cop on the stand. And because he scheduled that trial on July 16th, hours before another I already had scheduled in St. Charles County, I had to leave at 10:15, even though there was a showtime of 9 a.m., and I was there at 8:30. So I left, I finished preparations, attended the next trial, attempted trial. That one didn't go through either, big shock. Only to find out that when they discovered, he's making enough of a fuss, we can't push this to a trial today, even though we told everybody to come. They then said, what's this about a bench warrant arrest? So he filed an arrest warrant against me for failure to appear, even though I appeared, and had me arrested. And ordered me to pay $500 in order to get out. And that's the max penalty that I'm threatened with for these 2 traffic tickets, is $500. So what more could he do, right? And this is all in violation of the own law that says he's supposed to recuse himself. Because of corruption. That's why this law was invented and implemented in the first place. So that people could be like, I want an escape hatch because this judge is being corrupt. And so I'm just letting you know, because obviously this is all being recorded. And he thinks there is zero judicial oversight, because he's right about that. But he thinks that he can just do whatever he wants. So when you say to me, ma'am, and this is where I'm going, thank you for your patience, by the way, and professionalism. When you say to me, it's your time to talk to the judge today at 5, my response is, believe you me, I've tried that for several months now. This has been going on because he will not allow me to speak exactly this. He won't allow this law to be enacted in his room. I can't speak. I don't have the assistance of counsel. He won't let me have a jury. He won't let me be informed of the cause and nature. Obviously, I'm not presumed innocent. Obviously, this is not a fair and meaningful hearing.
Well, we don't do jury trials here.
That would be great if he would let me know that when I ask for one, because I never would trust his judgment to be a judge in any trial I would be judged by. Because of the obvious on the record of events of what he's done, no one has to believe my opinions. Everything's on the record. So when you ask me what's your question, that's what my question is. And if you're ready, I'd just like to move on to my next one so I take up less of your day. I know your time's valuable.
Yeah, that's fine.
Okay. So there was a filing in there that I'm seeing for September 2nd that must be some kind of clerical error. I have nothing to do with it. I have no idea what it is. It's a 2-page document. I've captured with screen capture everything. Has people I don't know, a defendant I don't know. It's something to do with somebody claiming some jurisdictional challenge and claims I have nothing to do with. I don't agree with it. And it's just posted in there on the public record for everybody to see, and I just want to know why. And can we fix that? if you look, you'll see it's September 2nd. Just click on that.
Talking about the motion to dismiss?
Well, it's not filed by me. I don't know who that's filed for or what case that is. If it's a motion to dismiss, it's not by me. I have nothing to do with this document. I've never seen this happen before. And just so you know, I've drafted a document. When I come in today at 5, there were 3 documents I'm going to file. Now there's 4. One is going to be just to address this simple clerical error that I have acknowledged it and that I disavow any knowledge of anything to do with it. I think it's something that handing to the prosecutor as a tip on how to deal with people who say the J word, who challenge jurisdiction at all. They're like, here's a way you can combat it. They just made a mistake.
So, I don't know if this was even supposed to be...
It's not. It's not supposed to be there. That's what I'm saying.
Yeah, this is not even you.
No, it's not. It has nothing to do with me.
I would have to check with the court administrator. It looks like he was the one that actually...
Yeah, and a court administrator
put it in there, so I would have to, and he's not here at the moment. I believe he stepped out for a little bit, so I would have to.
Okay, what's his name?
It's Jeff.
Jeff, okay. Because a court administrator should have nothing to do with filing documents on behalf of the prosecutor. I mean, the judges in the court's office should be fair, independent, impartial, balanced referees. Shouldn't be filing the...
Sometimes they file things to the court, and then they want us to have it attached to the court file as well, but that comes directly from their office to us.
Who's there when you say there for clarification?
The PA's office.
The prosecuting attorney's office. Okay.
Yeah, so sometimes they'll file stuff to the court, and then we file it on the court has a record of it as well, but that doesn't happen all the time. I mean, if we get something from them, then we do file it how the prosecutor wants us to file it. Let me write this down. So, okay, so your cases are ending in 706 and 707.
Correct.
Okay, so. Okay, so you're Joseph. This other person is Timothy.
Yeah.
Okay.
So I'm just noting something, and then I'll totally leave the subject, that any and all court administration is supposed to be, in a fair system, completely independent and separate from any and all prosecutor office employees. And if the prosecutor wants to file anything, they really should be doing it on the record as the prosecutor's office and not have some direct shortcut line to the court, because the defendants never do, that's for sure. And the defendants are obviously saying, hey, you guys are all licensed and paid by this same fictional entity. That's a big conflict of interest. And it doesn't help that perception of conflict of interest when this practice is so freely engaged because there's zero judicial oversight ongoing for decades. Everyone knows this. So I'm just saying that for the record, and I can just move on. I appreciate your time again.
Yeah, no problem. I mean, I'll pass this along to him and see. I don't know if this was an error or it was just...
It was an error.
It was just attached to the wrong person. That's what it looks like.
It was an error. They're accumulating materials in order to counter what they think I'm arguing, even though I'm not arguing anything. I'm just clarifying what they're doing. Or they're trying to find a reason to do a common tactic, which is to throw the prosecutor's office under the bus and dismiss all charges so the judge doesn't take the blame when all the blame should go on the judge. So I think it's one of the two, just for reference.
Okay. I mean, I hear what you're saying and I understand, but I can't speak on behalf of the judge, unfortunately. So,
yeah. I don't mean to put you in an awkward position.
I don't know what your approach was last time, but maybe you need to have a different approach when you come in today at 5 and see if he's more, willing to hear what you have to say. But that would be your opportunity tonight at 5.
Yeah, the approach that I always use is the one that I'm using now with you, which is calm, professional, don't interrupt, and let them speak if they do, and just try to get to the point as quickly as possible. That's the approach I use. It's just that the words that come out of my mouth are just so damaging to the system as is, and it just so happens to be landing on him, and so they give him the job of getting me to obey through coercion. And it's just never, ever, ever, ever going to work. I've been doing it for 10 years. I am undefeated. He's just the latest person that's going to find out. I've already done this to 2 judges in the last 4 years in Missouri, and they both caved. One within one hearing, one in the second. And I have an ongoing case with another, and I'm fighting that battle at the same time. And it goes nothing but awesome for me. This is all just laughing. It doesn't cost me any time or money to a lawyer or any of that. I'm not trying to be difficult. I'm really trying to be friendly and show to everybody, because I do this on YouTube for no money, by the way, whatsoever, ever, that, treat people well when they treat you well. And you can say what you have to say without blah, 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 preaching or any of this other time-wasting nonsense. So I'm just trying to get to the truth and move on. It seems a clerical error was made. It seems it's now scheduled at 5 p.m. today. It was scheduled at September 9th, by the way, for the longest time. I looked just this morning and discovered it was September 8th. I got no notice of that. That's fine. I don't even care about... I'm not asking for anything.
Was it on your bond sheet, though? Like, what court date did you have on your bond sheet?
I'd have to look that up. I don't have that right in front of me.
I have a copy of it. It looks like they gave you, your bond sheet says September 8th.
Well, see, and here's the thing. I get a pink copy, and on purpose, I can hardly read anything of it. It's who knows what this thing says. It's just sitting in a folder right now, and I don't know. They have my number. They can text me. They can call me. They can mail me. And I've told them this, and they don't do any of those. So, anyway, I'm not arguing that.
What's your notice? Well, I don't...
That's fair.
I don't know whether you
what?
can read it or not, but I'm looking at the copy that they gave you, and it does say for today at 5. So.
That might just be what happened. It just looks like a 9 to me, and it doesn't matter. I saw on the internet September 9th, and I've made YouTube videos with me staring at the screen and it's saying September 9th, but I don't need to make a fuss about this whatsoever. We can just move on. It's really not important to me. And then, let's see, did I have anything else here? I have a little note card here. No, we already talked about that, and no, you've answered everything else. So, yeah, I've accomplished everything, and thank you for your time. I'm going to be in there in about 2 hours, or whatever it is, 3 hours, and I'm going to be filing some quick documents, and I'm always super easy to work with, and, yeah, I appreciate it. I'll see you soon.
Yeah, all right. Okay.
All right, take care. Bye-bye. I'm never flawless. That's so far from perfect, but it's spur of the moment. I'm not... It's adequate, so that's it.